Hello friends, welcome back to a new video. So friends, today in this video I am going to share with you about the curative petition, what is its general meaning, and how is it to be filed before the Supreme Court, what are the conditions to be mentioned under Article 48 of the Supreme Court Rules 2012. So basically, curative petition is the last constitutional remedy which is available to a person whose review petition has been dismissed by the Honorable Supreme Court. On the topic of review petition, we have already made a separate video, you can see from the playlist, wherein we have stated the grounds and how it is to be filed before the Supreme Court. So when the review petition is filed, a curative petition is maintainable before the Supreme Court. Though the Constitution explicitly speaks about the review powers of the Supreme Court under Article 137, but it is silent about the curative powers. So the curative petitions was given shape and form in the case of Rupa Ashok Hura versus Ashoka Hura and another. Citation I am giving 2002 4 SSC 388, where the Supreme Court reconsidered its judgment in exercise of its inherent power to prevent abuse of its process and to cure a miscarriage of justice. It was explained in the said decision that the curative power of the court flows from Article 142 of the Constitution, which gives court power to do a complete justice. The court, to prevent abuse of its process and to cure a gross miscarriage of justice, may reconsider its judgment in exercise of its inherent power. Observed that 5-judge bench in that case, the Supreme Court observed that the powers conferred on the court by the said article is curative in nature and cannot be interpreted as powers which authorize the court to ignore substantive rights of a litigant while dealing with a case pending before it. And this power of the court cannot be used to replace the agency law applicable to the case or case without or under consideration of the court. In this case, it has also been held that we are of the view that though judges of the highest court do their best, subject of course to the limitation of human fallibility, but yet situations may arise in the rarest of the rare cases which would right miscarriage of justice complained of. In such case, it would not only be proper but also obligatory both legally and morally to rectify the error. So when and how to file the curative plea is very important point to know, and which this also had been laid out in the case of Rupa Hera case, which is in this case the 5-judge Constitution bench considered the question whether an aggrieved person is entitled to any relief against the final judgment or order of the Supreme Court after dismissal of the review petition, either under Article 32 of the Indian Constitution or otherwise. So the requirements to entertain the curative petition as laid down in this case has been given as except when very strong reasons exists, the court should not entertain an application seeking reconsideration of an order of the Supreme Court which has already become final or on dismissal of a review petition. So while acknowledging that it was not possible to enumerate all the grounds on which a curative petition may be entertained, but the court laid down the certain broad parameters for exercise of this power. So what are the conditions to file a curative petition? A petitioner in this case is entitled to relief under curative petition if he proves or establishes in his case that there is a violation of principles of natural justice and where he was not a party to the list but the judgment adversely affected his interest in it. Second, he was a party to the list but he was not served with the notice of the proceedings and the matters proceeded as if he has the choice. Third is wherein the proceedings a learned judge failed to disclose his connection with the subject matter, and the lastly is the parties giving the scope for an apprehension of a bias and the judgment adversely affects the petitioner. So in the case when the curative petition has been filed, the petitioner shall assert the grounds mentioned therein had been taken in the review petition, because the normally grounds which are the review taken in the review petition, which is mostly incorporated in the curative as well. The curative petition should also contain a certification by a senior advocate with regard to the fulfillment of the above requirements. The curative petition can be filed and it must be circulated to a bench of the 3 senior most judges and the judges who passed the judgment complained of, if they are available at that time. And it is only when a majority of the learned judges on this bench concluded that the matter needs on hearing, as it should be listed before the same bench, which may pass appropriate orders. The court also added in this case that it shall be open to the bench at any stage of consideration of the curative petition to ask a senior counsel to assist in this case as amicus curiae. In the event if the bench has failed to find that the curative petition is displeasing, it can also impose exemplary costs on the petitioners, heavy costs for filing such fabricated and frivolous curative petition before the Supreme Court. A curative petition is usually decided by the judges in a chamber. Unless a specific request is made for an open court, hearing is allowed. Another special reason is that there is no limitation period for filing a curative petition, but the court has said that it must be within a reasonable time. So there are certain examples of curative petition which are allowed by the Supreme Court, like the curative petition was allowed by the Supreme Court in the case of Navneet Kaur versus State of NCT of Delhi, and in this case the curative petition was filed by Navneet Kaur, wife of Devendra Pal Singh, against the dismissal of review petition wherein she prayed for setting aside the death sentence imposed upon him on the ground of supervening circumstance of delay of 8 years in disposal of mercy petition. The apex court in this case allowed the curative petition by commuting the death sentence to life imprisonment on the ground of inordinate delay of 8 years in disposal of mercy petition and on the ground of insanity. In another case, the Supreme Court set aside its own judgment, which held that action of a woman merely kicking her daughter-in-law or threatening her with divorce would not come within the meaning of cruelty under section 498 of Indian Penal Code. The 3-judge bench in this case allowed the curative petition filed by the NCW by restoring the special leave petition. So in a nutshell, in short, we can say about the summary curative petition is that before the origin of curative petition in Rupa Hure case, a writ petition was filed by the petitioner under Article 32 for the second time in the same case for reconsideration of a final judgment by the court to set aside the miscarriage of justice, and this was done in the case of A.R. Antule versus R.S. Naik and another. This is a very important case on this point, where the majority opined that in this case that a previous judgment could be recalled under a petition under Article 32 or under Article 136 of the Constitution of India. So we can say in view of the discussion that the idea of the curative petition is a constituent remedy, which is the last resort that was originated to rectify the decision of the Supreme Court, which was passed in a review petition by themselves, as a legal and a moral obligation in deciding the rarest of rare cases. So if you need any further point in such discussion on the point of curative petition, please let us know so that we can provide you the next information also. Don't forget to subscribe our channel and please be safe. Thanks for watching this topic.